The chair lays out House Bill 4240 and recognizes Chair Raymond to explain the bill.
Before you listen to this testimony, it's important to understand why it matters for family law reform. This video captures the full legislative testimony on a bill that did not pass into law at the time, HB 4240. It made it all the way through the House and Senate committees and onto the intent calendar. However, it never made it off the intent calendar. In fact, that's how they killed some legislative bills that had support. But testimony like this is how ideas enter the legislative bloodstream. It's where problems are named, gaps in the law are exposed, and lawmakers begin to understand the real world consequences of inaction in these family law courts. So even when a bill fails, the testimony doesn't disappear. It lays the groundwork for what comes next. And that's exactly what happened here. The bill that eventually passed took a few years later, and it passed in 2025. It's called Senate Bill 2794, but it addressed the same problem of custody interference by adding fines, consequences that are immediately enforceable by law enforcement, rather than leaving parents stuck waiting on civil contempt proceeding dockets. That enforcement framework is the same approach described in Chapter 18 of our book, which has been published since 2013. So as you watch this testimony, listen not just for what was said, but for how it shaped the understanding that ultimately made this reform possible. This isn't the end of the story, but just the beginning. Watch to the end to hear about the bill that did pass several years later, and then subscribe to our channel and keep watching our videos for learning how you can make an impact today. So let's check it out, you guys. Wait till the end, because that's where I go over the bill that actually did pass.
The chair lays out House Bill 4240 and recognizes Chair Raymond to explain the bill.
Okay. Members, so one of the issues I've worked on for a long time, and I think everybody except Mr. Cook and Mr. Vasood have been here for a while by now. So you know that sometimes you got to work on stuff for a long time. And through the years, had to deal with parents who were divorced or maybe never got married but had a child. And the child, of course, resides with one of the parents, but the court issues an order allowing the other parent to have visitation. And a lot of times you have problems with that for a bunch of different reasons, where the parent who has the child doesn't want the child to visit with the other parent, even though the court order said they will, and they should, and they have to. And so you have a lot of, unfortunately, a lot of incidents where that child is stuck in the middle, right? And so I've tried for years now. We've worked on it. And there's some other legislation that's been presented that is much more sweeping than the bill in front of you. However, after working on it for a long time with a lot of DAs, we've gathered here at this Capitol during interims and with meeting with a lot of parents and meeting with council members and police officers who have to show up at a home because, you know, one parent goes to pick up the child that they're supposed to visit with from Friday at 5 o'clock until Sunday at 5 o'clock, and the other parent says, no, you can't take them, or they're not there, and the child isn't there. And that's tough. I'm a parent, I love my children, and I can't imagine going through that, or having been a child when I was a kid to have gone through that would be tough. So we continue to try to work on something that might help the process, and in the end really help the children, because I think we know that a child who has the benefit of both parents just does better in life, right? Not that there aren't those who don't do well if they only have a single parent. We have plenty of examples of that. However, you love your father, you love your mother, you want to be able to spend time with both of them. So I want to read to you, I'm very proud that my city council passed a resolution. I hope you have it, and if you don't, I apologize, and I'll certainly get a copy to you. But I want to read the resolution that they passed because it pretty much lays out what we do here. It says, whereas Section 2503 of the Texas Penal Code provides that a person who knowingly interferes with the lawful custody of a child younger than 18 in violation of express terms of a judgment or order commits a felony, and whereas law enforcement and prosecutors around the state of Texas have found it difficult to enforce and have therefore deemed reports of interference with child custody to be treated as a civil matter rather than a criminal one, and whereas allowing law enforcement the authority to issue a citation, which is what we're proposing, rather than restricting them to arresting the accused person for violation of Section 2503, would grant law enforcement and prosecutors around the state the ability to enforce child custody orders more effectively. And whereas the City Council believes that the Texas Legislature should support any bill that would grant local law enforcement the ability to enforce child custody and child visitation orders, now, therefore, be it resolved by the City Council of the City of Laredo, Texas, that the City of Laredo calls upon the Texas Legislature to support the passage of a bill that would, in addition to the punishment available under Section 2503 of the Texas Penal Code, allow law enforcement to issue a citation to any parent accused of interfering with child custody. And so, simply, here's the scenario. A uniform shows up at a home because one parent is at 5 o'clock on a Friday is supposed to be able to take that child for the weekend, but the other parent says, no, you can't take them. List your reasons. A police officer comes, and that's what happens, and they assess the situation, and they know that, you know, the parent is legally, under court order, allowed to take the child. So if the police officer in that moment, instead of arresting and making that decision to arrest somebody, is allowed to issue a citation up to $500, that'll be up to the City Council, issue a citation, then that's going to go to municipal court. And the municipal court judge is going to hear it and make a decision whether or not, you know, to make that person pay that fine. And here's the thought process, and this was, candidly, was my idea. That happens 2 or 3 times. Then all of a sudden the DA and the district judge, they're going to take note. They're going to say, this is a repeat offender over and over and over. They keep doing this. They keep getting this fine. Something's going on here, right? And then they're more likely, and but candidly, my hope is that if that happens, maybe after the first citation, you're just not going to have it anymore, right? They're just less likely to want to go through that again. That's the thought. And this bill, members, to be very clear, would simply allow a city council, as they look at this, would simply allow a city council to establish that ordinance should they feel like they want to do that in their community. Obviously, I think in Laredo, they will do it. I mean, we've talked, I visited with the city council members, we've talked about it, again, visited with PD, visited with the DA, looked at the process, looked at what's going on in Laredo, and we have, at this point, I've met with people from all over the state. And so we think this is a moderate step forward, but one that can help. You know, you don't have to always end up in district court or being arrested to fix things. Sometimes there are other ways to get there. So this was a simple, but we think good idea, a moderate step forward. I think we have people testifying. I asked, you can imagine, we could have hundreds of people testifying. I didn't want that. But I think we have a few people that want to testify, and hopefully not very many against. So I hope that you'll look at this, members. Seriously, I'm going to talk to every single one of you to ask you to please pass this. I think it's a good moderate step. I think it can help the process. And if we become a pilot program in Laredo, which I doubt we will, I think other city councils will probably do it as well. Some will anyway. I think it'll improve the process and help kids. Bottom line, help kids. So the parents, you know, who aren't married anymore or maybe never were, don't like each other. Hey man, that's, you know, that kid loves both parents. Most of the time they're going to love both parents. And if the other parent wants to go through the process of getting to a point where there is a court order where the judge says you're going to spend, yes, you can spend time with that other parent too. Usually that parent wants to. If they've gone through that, they probably really do want to spend time with that child. And that's what this is all about. So I would be glad to answer any questions if you have any. I guess I should say I would try to answer questions now that I'm having this very able attorney over here ask me a question.
Chair recognizes Representative Ramos.
Thank you, Representative Raymond. And as a family law attorney, this happens a lot. And I like a lot of parts of it, but I'm concerned in terms of, like, how would I advise my client? And many times, you know.
Tell them to follow the court order.
Well, so we tell them to follow the court order. The cops show up and they're like, that's a civil matter, take it to district court. So I like the idea that they would be able to do a citation.
They don't have to. It doesn't say the police has to. What happens, and I've talked to a lot of police officers, I mean, you know, a lot of police officers are just, they're part of the community, right? So this doesn't say they have to give a citation. That says that they may. So it will allow them to assess the situation, which, as I've talked to police officers, they get pretty good at, especially sort of repeat situations, and they know what the situation is. So I think that they'll know. I think we're entrusting them, of course, to issue their judgment, but I think they're going to have some sense. You know what? I've got to take this to court. I'm not going to issue a citation. Or they'll say, pretty obvious, you're pissed off. I'm sorry. You're really mad at this person. You're really mad at them, but they have the right to be with that parent this weekend, and so you need to let them go. No, I'm not going to let them. Okay, well, here's a citation. They're not going to arrest them.
Well, no, I like the fact that they could get a citation, because in practice, to actually get an enforcement of child custody or possession enforcement, there is a lengthy process. You have to delineate specifically each time they denied possession, and all of these details are under the current code. And with the district courts, one of our judges said that district courts, because of COVID, the Office of Court Administration has estimated that they're about 3 years behind on cases. I mean, with all of the stuff that's going on in the hearings and delay and everything. And so they're trying to get additional judges. So I like the fact that this might be able to resolve issues immediately, whereas families, in my case, I represent a lot of working families, and so, and non-English speakers, and so they just don't see their child because they can't afford to go to the district court.
Exactly.
So they just, you know, typically, you know, in many of the situations I experience, mom says no, and they just say, okay, I don't want problems. So they don't see their child. And I think that really, really hurts. Of course, we know that really hurts the children. They're there because they want to see the child.
Right.
But my concern, and my concern is that police officers, I guess, in part of this process, should a city adopt the policy? Because I like the fact that it allows it's discretionary, right? If a city chooses to do that.
Right.
But I mean, I just would want to make sure that our police departments are adequately educating our law enforcement, because one person could come out with a temporary order and somebody else can come out with the final order, and their timelines, and then cops are confused. So we're asking them to kind of.
Well, I think that a couple of things. One is, you know, when the phrase defund the police was started by some Republican operative to try to hurt Democrats.
Yeah.
I immediately told all my Democratic friends, it's not about defunding the police, it's about investing more in the police. I absolutely believe that, always have. It's about investing more, precisely for reasons like this. And so I think departments would, I mean, I think a city council, were they to pass this ordinance, would take that into account. I think they would make sure, I hope they would make sure, I know they would in Laredo, that the police officers had some familiarity with it. But again, if a police officer, you know, they're not always going to get it right. None of us get it right up here all the time, except Jeff Leach. You know, we don't all get it right. And but if they don't get it right, again, you go in front of a municipal judge, right? And I think that's a less cumbersome, less costly experience than having to go in front of a district court. And by the way, quicker. So.
Thank you, members. Any other questions for Chair Raymond? Chair recognizes Representative or Vice Chair Swanson.
Yes, ma'am.
This sounds like a great bill.
It is.
Okay, just checking.
It took a long time. It took me 6 years, believe me.
Really? Wow.
I've been meeting with folks for a long time, and there's a really big, hard way to solve this. And then this is much easier, I think, to make progress.
I've long thought that it's just too hard for people to enforce the court order, and there should be something simple. Question, you're talking about cities only, and some of the summaries I have say municipality or county. Can counties do this?
I think I wrote it up as city. Let me see if, I don't think I, oh, I'm sorry, it is city or county. I apologize.
Okay,
Yeah.
great, because my
Because if
district,
it's unincorporated.
my district is almost totally unincorporated,
Yes,
so
ma'am.
I
Yeah.
like that.
I forgot we put that in because we knew you were on the committee and we wanted to make
Well,
sure we covered that.
Talk to me later about where to sign up for the bill.
Yes, ma'am. Any other
Members,
questions?
are there any other questions? Okay, thank you, Chair. We'll proceed to testimony. We have a Zoom witness, Stuart McMullen. Chair calls Stuart McMullen. If you can please turn your video on. And can you please state your name, whom you represent, and your position on the bill?
Hello.
Can you please state your name, whom you represent, and your position on the bill?
My name is Stuart McMullen. I represent myself, and I am for the bill.
You can proceed.
Okay. The current Penal Code 25.03 has historically not been enforced, and so there's really no consequence for the parent who is interfering with the child custody. There's really no consequence when they violate that. So I believe that imposing a civil penalty similar to a traffic ticket would help with this issue. I've had my child being withheld from me, and I've called and made reports with Williamson County, and they just flat out won't do anything with it because it's a severe consequence. It's a state jail felony, and most of the time the DAs don't want to put that charge against a parent just because there's some sort of dispute. And honestly, because I know that there's no consequence, I would withhold my son in retaliation just to get the time back, knowing that nothing was going to happen to me. But if you pass this law and the responding officer has the opportunity to write a ticket for up to $500 for interfering with child custody, I think that will be enforced, and that these parents that are withholding the children would stop. It would act as a good deterrent for these parents who are withholding their children from the other parent.
Mr. McMullen? Mr. McMullen,
Yes.
Can you hear me? So it appears you're driving. I would just respectfully ask that you pull over during this testimony, and we'll give you another, please.
Okay. All right, I'm stopped.
Thank you. You can proceed.
So that was the bulk of my testimony. I would add that since my ex-wife and I have agreed to 50-50 equal custody, there has been no more issues. So if equal custody was the norm, then we wouldn't really have many issues with interference with child custody. But I do think that a civil penalty is a good alternative to the state jail felony charge.
Thank you for your testimony. Members, are there any questions for this witness? Okay, thank you.
Thank you.
Chair calls George Saldana. You can please state your name, whom you represent, and your position on the bill.
Good morning, everybody. My name is George Saldana. I'm in support of House Bill 4240. And first of all, thank you. I'm a father that had his 3-year-old.
Mr. Saldana, just to clarify for the record, are you representing an organization as well?
Oh, I'm sorry. Yes. Myself and Texas Team 2503, a grassroots organization out of San Antonio. I myself am a father that had a 3-year-old son that I didn't know the whereabouts for 22 months. I couldn't get law enforcement to help me. I had to go to my legislators and talk to them to seek resolution or relief. We couldn't do anything in court. We couldn't find them. We couldn't get them served. Our organization has done some great work. I'm very proud of my members that volunteer their time for the betterment of the children for the state of Texas. This is just San Antonio's numbers on a public information request. There's 12,354 visitation violations in 2016. The reason I carry this box around is because I want everybody to just see that what it looks like, 12,354 visitation violations. And, you know, we spoke with Representative Raymond on this issue. We've been working with him. We've got support from the Texas District and County Attorneys Association. We met with them. And this is a very good bill. I would ask that, you know, with Representative Raymond's humorous testimony that, you know, we're doing great things for children when we do this, only because children, when they have two parents involved, are 80% less likely to go into the criminal system. So right now, earlier today, we just heard testimony about, you know, trying to help the children that are been incarcerated. That was one of another public information request we asked for is from the Bexar County Juvenile Detention Centers. How many of these children are coming from single parent households? Myself as a father, I have done everything I can to be in my child's life. I'm not a deadbeat. You know, we've made this great organization, which is 50-50 women and men. So we don't help just custodials. We help everybody, and it's real easy. Just follow the order. That's all we advocate for. We're not doing anything unlawful, unethical, or immoral. All we want is access to the children, as the judge has already deemed in the best interest. Thank you.
Thank you. Members, are there any questions for this witness? Okay, thank you for your testimony. Chair calls Derek Berry. Can you please state your name, whom you represent, and your position on the bill?
For the record, my name is Derek Marshall Berry, Reverend Derek Marshall Berry. I've had the pleasure of serving as the Communications Director for Texas 2503 and representing myself as well. I am for HB 4240. On the behalf of Texas parents everywhere, I thank you all for your tireless efforts, continued dedication, and the opportunity to speak today. I come before you as a single father of 3 beautiful and amazing children who I love and adore. Like many Texas parents, I had a long, lengthy, expensive litigation process. Despite having a current valid court order deemed in best interest of the child by a judge, mothers, fathers, custodial and non-custodial, myself included, face access issues while trying to exercise their possessionary time with truly little to no enforcement at their disposal. All too often, they are told by frontline law enforcement it's a civil matter to go back to court. HB 4240 allows a few key things to happen for all parents and guardians in Texas with current valid court orders. It helps and aids in the documentation process to demonstrate the pattern and the alienating behavior from the offending party. Parents are usually turned away empty-handed without child and/or a report documenting the infraction. It also adds a level of transparency and accountability towards the offending party, and in long term, frees up law enforcement resources to be utilized elsewhere, minimizing the custodial exchange standby currently being misused and labeled ineffective. It also has the ability to align any SOPs, standard operating procedures, currently being deployed with the Texas Penal Code. Ultimately, HB 4240 provides a reasonable, real-time working solution for all Texas children to have access to both loving parents, solidifying the Texas Children Bill of Rights and loving and caring order, often embedded in common practice in custodial agreements. It is with great hopes that HB 4240 serves as a deterrent from that repetitive alienating behavior, allowing the child to have both a nurturing relationship with mother and father. May God bless you on your tough decisions ahead, and may God bless Texas.
Thank you. Members, Chair recognizes Representative Ramos.
Thank you, Mr. Berry. And I'm trying to work through all of this out. And again, if I'm talking to a client, what do I tell a client? And all that we do. And many times, again, for working class folk, they don't hire attorneys a lot of times. They'll go straight to, for example, non-married couples, an individual gets pregnant, has the child, goes to the child support office. Within the standard child support order, there is typically a visitation schedule. So it's your standard visitation schedule. The individual didn't have to pay anything. The AG's office does it. Right now, we know with that comes a child support payment fee structure, and in Texas, we're billions of dollars in arrearages and unpaid child support. So I'm not trying to be cheeky, but if we do this, you know, doing this for possession so that dad, and I'm generalizing, but typically dad could have access to the child. But in the way we practice family law, child support and possession are two separate issues, right? So with the child support order, dad could essentially be $10,000. We know the AG's office is behind on enforcement. I mean, it's a whole big deal. So dad could be $10,000 behind on child support, but show up Friday to pick up the kid, right? And so should we not also include a civil fine for dad every time he shows up and doesn't pay that child support? Should dad not also get a citation by the cops because you were supposed to pay me child support this Friday and I didn't get anything, so take the kid, but you give me a $500 ticket and I'm giving you one for child support.
Sure.
How does that work with this? What should we do?
That's understood, but as you said, child disbursement and child visitation and access are two separate independent topics. Regardless of the money scenario, no parent should be denied and no child should be denied both loving parents.
I agree with you. I just think maybe, passing this law, then mom will be able to serve dad at that time so that she can get the enforcement and put his ass in jail for being $10,000 behind on child support. So, I mean, I guess it's a better way for mom to find dad as well to get,
make him, escalates the process and
hold him
provides
accountable. Yeah. Okay. Thank you.
Members, any other questions? Okay, thank you for your testimony.
Thank you very much.
Chair calls Kimmy Lynn Reed. Can you please state your name, whom you represent, and your position on the bill?
Yes, ma'am. My name is Kimmy Lynn Reed. I represent myself and Team 2503. And what was the last question? My position is I am absolutely for it. So in consideration with the fact that we have a family law attorney, I would like to go ahead and allow you to correct me if I'm wrong. There are two scenarios that enter the family court. You have normal ranged individuals who get a divorce, and then you have a party that contains one party that is not normal ranged. These are the people that have all of these issues. These are the people that will go to the end of the earth to destroy a healthy bond with their child. You enter the court, you get a temporary order. That temporary order, within a very, very short period of time, somebody doesn't have access. Somebody's not being given their access. Within another very, very short period of time, there is most likely a false allegation. Within another very short period of time, you get an ex parte hearing where you get to go and have your rights to your child taken from you without even being able to defend yourself in that ex parte hearing. An extended period of time goes by where yet again, the same parent has been given the opportunity to be enabled to withhold that child. Another extended period of time goes by while they try to prove somebody is normal range. So in this system, you are positively guilty of whatever false allegation has been alleged against you until you prove yourself innocent of those allegations. Never mind that prior to those allegations, you were a perfectly fit and loving parent. Suddenly you are not. You waste all of your money, assets, and resources in order to redeem yourself to prove I am a healthy, fit, and loving parent. And by the time you do all of that, you no longer have any money to go back to court and say, may I please have access to my child? Because all of your resources are gone. At this point, you have PTSD. You cannot represent yourself properly. You are emotional, and your child does not have access to you. You're out of everything and you're depleted. The reason why we are so for this, you've heard people testify today that the DAs are hesitant to enforce Texas 2503 because they don't want to enter into civil litigation and put that penalty on somebody. Meanwhile, these same parents are fighting false allegations of abuse. They're being thrown into jail for criminal trespass with valid court orders in their hand. We're getting police officers that show up that don't even realize that the offense they're showing up to is an actual civil defense or a criminal offense. If this bill was passed, it would affect my life very, very specifically so. The pattern of behavior for these individuals is identical. It may happen slower or faster, but it is all identical. And if this bill was passed, the very first time the pathological parent withholds the child and he gets a fine, I finally have something to stop all of the rest of it.
Thank you for your testimony. Members, are there any questions for this witness? Okay, thank you. Chair calls Erica Carrillo. Can you please state your name, whom you represent, and your position on the bill?
Good morning. My name is Erica Carrillo. I represent myself and I am with Team Texas 2503. I am for this bill and I will tell you why. I am a custodial parent and I have not seen my daughter in over a year. Father has taken her from me. Police will not do anything to help in my situation. I have tried to file many offense reports. They say it's a civil matter. They tell me go back to court. There's nothing we can do for you. In the process of trying to file a civil matter, I was retaliated against with a criminal trespass. So now not only can I not go find my daughter at the last known address she was at, I will be in offense of a criminal trespass if I do go and try to find my daughter. Again, law enforcement will not help me. I do not know where she's going to school. I don't know where she's living. And it's going over a year that I have been trying to fight the system to even just have access to see if she's okay. So, I mean, prior to all of this happening, we were very close. We did, family functions and things of that nature. Due to this and no one being able to help me or just refusing to help me, I have missed her birthday. I've missed Christmas. I've missed school functions, all of which were pivotal moments that were in our lives. So in closing, I do implore that you are in full support of HB 4240 for all of Texas parents, custodial and non-custodial alike, but mostly for the benefit of our Texas children.
Thank you for your testimony. Members, any questions for this witness? Okay, thank you.
Thank you.
Chair calls Sarah J. Johnston. Can you please state your name, whom you represent, and your position on the bill?
Hi, my name is Sarah J. Johnston. I am here to represent the Fathers' Rights Movement. I know that seems a little weird. I'm not an ad, but that's okay. So we are actually in favor of this bill. The reason why is because a lot of people think with our name that we are about fathers, but we're not. We're actually about children. The name, though, is how non-custodial parents, Representative Ramos hit it on the head, 92.47% of custodial parents in the state of Texas are women. So the non-custodials, how do they find us to protect their children? The father's rights. So here's the problem. Our family code is set up in a winner or loser system. This right here, this bill is the ultimate way with our companion bill that I won't talk about to help fight that. When you have a winner and loser system, it starts when we go into family court and we go in there and we are going to annihilate the other parent so we win. Because if we don't win, we get 25% of our child's life. So that just continues. Some people come out of court and they're okay. They go about doing what they're supposed to do. But the majority of them, we've seen a really huge increase. And I'm sorry, guys, I'm a little emotional. I just read about another man whose children were murdered due to the increased litigation and the increased fighting and parental alienation, which this has to deal with. So I'm a little emotional. So should not be about mom. This should not be about dad. This is about those kids. Each one of you should have gotten the stats. You know, having a father absent home, which I can call that because we know the custodial parent numbers, and the risk that that puts on those children. When you have them at the cookie cutter, 25% of our standard possession order, and we are allowing this type of behavior to go on, we're putting them further at risk. We're already endangering them, but this just keeps it going. So if you want to stop the school to prison pipeline, we need to make sure both parents are involved. We need to protect those kids. We need their mental health. We need their emotional health. We need their physical health to be protected. And I know it seems silly, but so did the lunch bill last year. But a fine would help, because the first time somebody does it, if there's a consequence, just like with our kids, they're probably not going to do it again. And the only people that would go past the first couple would be those real severe parental alienators that we need to handle in a separate manner.
Thank you. Members, are there any questions for this witness? Okay, thank you for your testimony.
Thank you.
Chair calls Taryn Champagne. Can you please state your name, whom you represent, and your position on the bill?
Good morning. My name is Taryn Champagne. I am representing myself, and I am for this bill. This bill adds a much-needed method for the localities to enforce the criminally underutilized Texas Penal Code 25.03, interference with child custody. This bill would help a large number of Texas children who have parents that are simply trying to see them as specified by their particular court orders. When a fit, willing, loving, and able parent with a valid court order wishes to exercise their parenting time, there should be no reason that they should be denied. A huge problem is that despite this being a state jail felony, this law is not enforced. To give you a picture of this, I have some information from calendar year 17 from Houston and Fort Worth. In Houston, there were a total of 1,019 calls made to the City of Houston Police Department related to interference with child custody. In the overwhelming majority of these cases, 981 or 96.27% of the time, all that is done is a report is made. In only 3 cases, 0.29% of the time was an arrest even made. For Fort Worth in 2017, there were 998 calls made related to 25.03, and of these 998 cases, only 3 arrests were made, 0.3%. For the people experiencing interference with child custody, they are given a song and dance routine by the police where they are told that there is nothing they can do and that is a civil matter despite being a law in the Texas Penal Code giving them the power to send them to jail. Those same people are then told that they need to get a lawyer and file a case with the local court. This clearly illustrates, like most things in family court, you get the justice you can afford, not the justice you deserve. This bill would allow the counties or municipalities to at least provide some consequences, since it appears the counties and municipalities are currently flagrantly disregarding the direction of the Texas legislature and are doing nothing to help the children. None more so than, for example, Mayor Reagan Johnson of Mineral Wells, who's been withholding the children of the father since May of last year. Access denial is not my problem, but I have watched over the past several years as many of my friends have been denied access to their children, whether it be one incident or for years at a time. They have sunk thousands of dollars into just trying to be a good parent to see their children. This is heart-wrenching to watch and causes the alienation of that parent. I encourage you to vote favorably on this bill, ideally using one of those expedited Thursday meetings you've done over the past 2 weeks, and consider that the issue of this would be solved in many cases by parents starting off at an equal possession. Do I have any further questions?
Members, are there any questions for this witness? Thank you for your testimony.
Thank you.
Chair calls William Morris. Can you please state your name, whom you represent, and your position on the bill?
Yes, my name is William Morris. I am the Vice President of the Texas Family Law Foundation that I represent. I also practice law with the firm of Gray, Reed, and McGraw. And we are for this bill with a couple of reservations. We agree and appreciate Representative Raymond bringing to light the situation and problems with possession and access. They are ongoing. I spent 11 years in Harris County as an associate judge and am very familiar with people coming in and saying, I couldn't get to my kids, et cetera. And there are some technicalities in the family code which have been set up by the Supreme Court. They need to be enforced, and this method would do it. Part of the reservations I have is whether or not that would then prohibit somebody, if they got a fine, they went in, pled no contest and paid the fine, could you go in and hold them in contempt in family court at that point? Or would this interfere in that problem, using that same incident to interfere with the ability of the court to hold them in contempt? This would carry a fine. Contempt carries both fine and possible imprisonment up to 6 months for each one. So while we think it's a good effort towards enforcing this problem, perhaps some further thought needs to be given.
Chair recognizes Vice Chair Swanson.
Yes, thank you, Chairman. Okay, so you bring up a great point here. Is this something that you think could easily be amended in the bill and we could have a committee sub that would make everybody happy?
I'm not sure it could be amended in the bill because you're talking about constitutional provisions. I'm not a criminal lawyer, so I'm not quite sure how somebody going in and saying, I plead guilty to this, fine me $200 or whatever the county or city has said. Could you then go use the same thing and, okay, hold them in contempt under your court order, Judge, for doing that? And I'm not sure that can be cured.
Okay, it looks like the author's wanting to address that at the end, but it seems like you could have a simple sentence that says this does not prevent da-da-da-da. Okay, well, thank you.
Chair recognizes Representative Wu.
Yeah, thank you. And so I think maybe you'd be the right person to help me understand this a little better. I don't practice at this area of law. Why not do this through contempt proceedings in family court? Like that's what I would think, that if there was a court order saying that you're supposed to have custody at this time and the person just ignores it completely, why not address it through that process instead of having a separate legal proceeding?
There are two reasons I can think of. One is time. Get a ticket from a police officer, they set a time 2-3 weeks down the road. If you go to your lawyer and the lawyer or DRO, Lone Star Legal Aid, files a contempt on your behalf, have to serve the person with process, they're entitled to at least 10 days notice of the hearing under the Family Code, Chapter 157, and then they go to court. So shorter time frame, more, we all know that the sooner you get your hand slapped, get too far away from the incident, the less likely you are to remember it. And the other one at age 75, I can't remember what my second point was. But
Is there any concern that this could be abused? Just like, that someone with, like a parent with more knowledge and more skill could use this to just cause problems?
certainly, if you had somebody of means and they wish to just go pay a $200, plead no contest and go pay a $200 fine every time rather than pay a lawyer $3,000 or $5,000 to defend them, it might be worth their time to just blow it off and go pay the fine, plead no contest, so it couldn't be used against them.
Members, any other questions? Okay, thank you for your testimony.
All right, thank you.
Chair calls Cassandra Spencer. Can you please state your name, whom you represent, and your position on the bill?
Thank you. Thank you, Madam Chairman, woman, and members of the committee. My name is Cassandra Spencer. I represent myself, and I am in favor of this bill. I'm basically, if you guys want to see what the end result of some of these extreme family court situations can be, I'm a custodial parent who has not seen their child but twice in over 3 years. My daughter is not living with me. She's not living with her father. She is living with my father in the state of Virginia, where she has not been in school for over 2 years and is living in a situation that I feel completely comfortable describing as a religious cult. The current system escalates these situations. It encourages these situations to escalate by forcing parents to their go-to recourse is to have to hire expensive attorneys and try to seek a contempt order instead of what can be easily resolved with one call to the police and potentially a fine. I also want to point out that I view this as a veterans issue. In addition, most people know me as an undercover journalist and a corporate whistleblower, but I'm also a military veteran of 8 years. I cannot tell you how many soldiers I have seen be on the victim end of parental alienation, as well as having experienced it myself. So many of our service members are the non-custodial parents. Whether that's right or wrong is another issue. Whether, current possession schedules, that's another issue. But so many of our military service members are the non-custodial parents. And so many times they are denied access to their children during what time they do have at home, between deployments, between exercises, due to this system, that their only recourse is to go through a timely family court proceeding that oftentimes our service members aren't able to make these hearings. It's unreasonable to expect them to be able to. Sometimes they're not living in the state that the child is. And I just think that providing the civil penalty de-escalates these situations so that it does not get to an extreme level. Would this make an immediate difference in my case? Would this help me get my daughter and be able to see her? Absolutely not. But I would like to think that if Texas adopted this and if more states adopted measures like this that could de-escalate these family court situations, that it would actually solve a lot of our societal issues that we face today. And I'm more than happy to take any questions.
Thank you for your service. Members, are there any questions for this witness? Okay, thank you for your testimony. Chair calls Lindsay Irwin. Can you please state your name, whom you represent, and your position on the bill?
Good afternoon. My name is Lindsay Irwin. I represent the Texas 2503 team. I'm the research lead, and I'm in favor of this bill. The reason I'm in favor of this bill is because I am a survivor. I'm the child. I am the product of divorce. I was alienated 20 years from one of my parents. This does not stop once the court order is over. It doesn't stop at 18. It doesn't stop when the child graduates. This goes into adulthood. This goes into affecting grandchildren. This is something that the local authorities need because they are the closest, they are the first on the scene to the children. Because those parents cannot afford to go into a district court. I mean, you're starting at $5,000 a retainer to hire an attorney. And let me explain something to you. Out of the 9 years that I've been an advocate for this type of situation, the first time you go into a contempt situation, the favored resolution is awarding extra time. And that's perfectly fine. That's wonderful. But once that parent goes to exercise their court-ordered time or even their awarded time, there goes another denial. They've done it for so long. These repeat offenders are not being held accountable. They have to be held accountable because they're getting away with it. My mother was never held accountable for her actions, and she is doing it to 3 other siblings that I have that are still minors. This is something that is needed to put into place to protect children. I was not protected. I was not afforded any type of resolution. This is a tool that our law enforcement, that our local authorities need. There are other tools in place now, but this is the fastest, this is the quickest thing that is going to give them a hands-on, an immediate, hey, I'm going to give you a fine. And you need to stop this. And if you continue to have a problem with this, then just go back to court. They can go back to their same narrative of just, hey, go back to court. But in the meantime, they need something faster. They need something to protect these kids. Thank you for your time.
Thank you. Members, are there any questions for this witness? Okay, thank you for your testimony. Chair calls Faith Bussey. Can you please state your name, whom you represent, and your position on the bill?
my name is Faith Bussey. I'm with Just Liberty, and we are against this bill. But first, I need to apologize to the representative who brought it because I just found out about this bill like last night, so I haven't had a chance to talk to him or his office about any of our concerns. And I fully understand that this is a problem, that every bill filed is trying to fix the problem, and child custody issues are certainly obvious and glaring. They have issues. So my apologies there, and I only have a couple points to make. First, it is important for this committee and every lawmaker to understand that fines don't exist within a vacuum. Every fine, especially in poor families, has an impact, not just upon the offender, but upon the single mom or dad to whom they have to pay child support. $500 goes a long way to keeping a roof over someone's head or paying an electric bill or making a car payment. And second, and this is maybe the most important part that folks tend to forget, warrants can mean every unpaid fine goes to a warrant. And warrants can mean unnecessarily escalated tensions when that individual is pulled over. Warrants can mean that person will be going to jail still instead of going to their job to pay for their child support or to pay for the fine. It is a lose-lose situation for everybody. And that's before you get into the proper role of local and county governments getting involved in child custody disputes. So again, we understand there is a problem. I don't know that this is the best solution, and we would definitely love to talk about it more. So thank you for your time and consideration.
Members, are there any questions for this witness? Thank you for your testimony. Chair calls Jeffrey Morgan.
Jeffrey Morgan is sitting in.
Is there anyone else who wishes to testify on, for, or against House Bill 4240? See none. Chair recognizes Chair Raymond to close on the bill.
Thank you. Excuse me. Thank you, Madam Chair and members. You know, you know what I wish we had? I wish we had a bunch of kids in here whose parents don't live together, or divorced, or never got married, and who are on the receiving end of what we have right now in Texas, right? With all due respect to I don't remember his name, the former judge. That's what I wish we had in here. And I want every one of you, and the ones who aren't here, I'll talk to them later, members who aren't here, but I want you to think back to your own life experiences, because I think to mine. My parents were married. They stayed married till my father passed away when I was 36. And I'm 37, I still miss it. I still miss the times that I spent with just my father. I love both my parents, right? And I love all three of my children. And I love when we would be together as a family, but I also loved, and I remember so fondly what those experiences meant when I was just with my mom or just with my dad, and I spent that time with them. It leaves such an impression on me and on you, I bet, if you think back to your own life experiences. Not that you didn't want to be with both your parents. I love being with my daughter. When I'm alone with my daughter, or with one of my sons and my other son who passed away, I love the time that I was alone with him. And so what we have today in Texas is a very terrible situation. And Mr. Wu, no, I really don't believe, well, or maybe not Mr. Wu, whoever testified. Really? Oh, they get a citation, they're gonna go in front of a municipal judge, you know, no contest. I plead no contest. Yeah, I did it. No, that's not the way it's going to go. It's not going to go like that. The person who got the citation is likely to say, well, no, I did it because whatever. And the judge has to make a decision. And the judge will look at it. And if the judge finds that that child should have gone with a parent that weekend, then the judge's going to fine him. May not be $500, might be $100, might be $250, whatever it is. It's going to get their attention. And do I think, are you kidding me? I mean, the courts are so backed up already on criminal cases and on civil cases, the district courts and county courts. Do I really think all of a sudden, oh, now they're going to go and take it to civil court now because they pled no contest on this municipal ordinance? Fine. No, man, that's not the way it's going to play out, with all due respect. And I recognize that every time we introduce a bill and we argue for it, that we're all being hypothetical, because it's a hypothetical situation. We don't know how Mr. Cook's bills are going to turn out, or Mr. Wu's bills are going to turn out. If they actually become law, they become law. We see how it goes. And if it doesn't work well, we meet again 2 years later and we change it. And sometimes we do. Sometimes we do. Okay? But in this case, members, and you know, Madam Chair, this is a big deal. It's affecting a lot of kids. And the current situation sucks for those kids. And I wish they were here right now. And I bet they'd tell you, yeah, I like when I can spend a little time with my other parent because I love them too. And if they care enough, if they care about their child enough to show up at the doorstep and want to take them for the weekend, because that's what the judge ruled that they can do, then let them. Let that kid spend time with that parent. This is not a terribly complicated proposal here, and there's not a whole lot of things around the corner that some up here might say, even those apparently that are in favor of it, are seeing things around the corner I don't think exist. But if they do, and Madam Chair, I'm going to bug you to pass this. I'm going to bug you to take a vote on it. I'm going to bug you, Chairman Leach and others, to please help us move this forward. And Gene, you spent a lot of time on this stuff. You know we got to do something better. And this is, I think, a good moderate step. And if it makes people feel better, put a sunset date on it. Make it 2 years from now. And you know what I believe will happen? 2 years from now, you'll be introducing the bill to do away with the date so that it can keep going. I think that's what's going to happen. I think it will have a positive effect. And with reference to the child support, rock and roll, man. I mean, that's something else. It's another deal. But I promise you, in most cases, I believe if that parent is showing up because they want to spend time with that child, they're probably up on their child support. And if they're not, it may be COVID related. A lot of people lost jobs. It may be because they just lost their job. That doesn't mean they don't love their kid anymore. I've met parents through the years. Look, I've been a state rep for 27 years. Can you imagine how many child support cases I've worked on? A bunch. So I've met some good ones and I've met some bad ones. I've met some where it's clear the parent is trying to keep up with the payment. If they get a job, take it. They don't have any problem with them taking it straight out of their paycheck because they love the kid. So, you know, members, as I said at the beginning, I've worked on this for a long time, this issue for a long time. And it was this last year, which was a very hard interim for me, but this last year, as we continue to discuss it, and my city councilman, my personal city councilman, who's a doctor, a physician, got involved in it. He said, man, can't we do something here? Can't we do something at the local level? And because we all are trained to try to figure things out, it just popped in my mind. I said, well, shoot, what if we give the PD the ability to write a ticket and let that municipal judge take a look at it? I believe human behavior, humans, we can be sort of encouraged to do things right. You get a ticket or two, my guess is you won't get more than one, and then you'll start complying. If that parent is in fact entitled to spend time with the child, you'll stop hiding the ball. Worse, stop hiding the child.
Chair recognizes Representative Ramos.
Thank you so much, Representative Raymond. This may surprise you, but I'm a feminist, and
it does surprise me.
But it bothers me so many times. I hear my clients who are male say, you know, I can't get my kid. She won't let me get my kid, and the children are absolutely missing out. And it's all about money, right? Whoever has the money to go to court. The reality is family law is a business. And that's the horrible part of it, because it's
true.
about
Which
people,
has prevented other legislation from passing. I get it.
Yeah, and it's about who has the money to go. The district courts are tied up. To do an actual enforcement is very expensive,
right, and
it's a very lengthy process.
Right.
But I think it sends the right message to these individuals who are denying access. And you know, child support, it is a separate issue, but the reality is the child does need to see both parents. And if dad is showing up, and I'm, you know, generalizing, but typically it's the mother and she's making it. I've had so many male clients saying, she said I couldn't, so I'm not going to. And I'm like, she doesn't have the right to make that decision. But they feel that moms, and I'm generalizing, but many times say, no, I get to call the shots on who gets to see and when and whatever. So fathers are just stepping out. They're just stepping out of these lives because they can't afford to spend all that money to go to district court, and really neither can moms. In the cases that I represent, some people are millionaires and they enjoy doing this.
Right.
But the reality is it's about the kids. So I think it's a great bill. I mean, we're going to learn and we're going to grow through it, but if the individuals...
Put a sunset date on it. I'm serious. Put a sunset date on it. I don't care if it's 2 years. I promise you, we'll be back here in 2 years and go, man, this is working. And if it's not, then it's gone. If there's some real concern or hesitation, put a sunset date on it.
But we need to ask ourselves, what's the alternative? The children don't get to see their parents, and then the children are denied access to the parent. What's the alternative? And introducing this, I think, is going to have some really good, really great impact.
I think it might, and again, not every community will do it.
Right.
I think some will, not everyone will, but I think some will, and they're going to try it. And again, we'll see, but I feel like it's a fairly non-punitive way to make people move and change their habits. Because when you get a lawyer that just say, look, we can hide the ball here, the kid gets lost in the process, and we forget that. The children get lost in the process. And again, I'm looking at it as someone who loved my time with my parents and candidly with my grandparents. I was very lucky. And then with my children.
Mm-hmm.
And, I just, and through the years, because I've been there so long, I mean, I've had instances where I've helped women who are on the receiving end of, not being able to see the child as well. Yes, a lot of it is going to be men, but it doesn't matter to me. That's why I don't say men, fathers, mothers, because it doesn't matter. If it was 90% women, would it be any different? Would it? Would it? If 90% of the parents, that weren't able to see the child are women, would it be any different? It shouldn't be. It shouldn't be. Because at the end of the day, it's about that kid. It really is. And they only have, we know by now, many of us, man, 18 years go by so quickly.
Mm-hmm.
And they are so formative in terms of helping build that relationship. Right.
Right, and I think this actually is in the best interest of the children, so it's a great bill. Thank you.
I'm trying.
Thank you. Members, any other questions for Chair Raymond?
And thank you, Madam Chair.
Thank you, Mr. Chair. At this time, House Bill 4240 will be left pending, and the chair will
this is constantly a civil rights battle between parents and trying to protect their rights and time to their children. And just because these bills passed doesn't mean it's over. The courts will still violate. So you still need to learn this, and you need to be one of the people that is documenting what is happening to you, what is happening to your child, so that the legislators can identify more gaps in the law and we can keep improving how this is addressed in the family law courts to protect our communities, to protect our future children who are future leaders, and to maintain the consistency and respect for authority. This is so necessary, and everyone that has participated, thank you so much.